Hello everybody, welcome back to the Butterfly Monkey channel. Today, of course, is a continuation on our reading of American Jurisprudence, second edition on Business Trust, volume 13. Today will be section 9 of that chapter, Termination and Dissolution. Actually, it will involve another chapter too. To read what it is Receiver. So it'll be section 10, Receivership, Reorganization, and Merger. About good 10 pages. So hopefully you guys enjoyed the other videos and watched them thoroughly. And of course, like and subscribe. It will compel me to do more. So section 92, generally. Trust instruments frequently provide a stated term for which a business trust is to operate, or prescribe the conditions under which it shall terminate. Upon the happening of a certain event or the expiration of the term for which the trust is to continue, and as in case of trust generally, a business trust will expire. Right? Trustees are natural persons. They have to die at some point. Otherwise, it's a corporation. And where the instrument of the trust provides for a definite period of existence, it may not be circumvented by the device of conveying the trust property to new trustees for a term longer than the residue of the original term. So this I would want to read specifically, right? Where the trust instrument of a trust provides for a definite period. So the trust is going to die, period. It may not be circumvented by the device of conveying the trust property to new trustees for a term longer than the residue of the original term. So if you notice, they don't say conveying the property to a new trust. They're just saying everyone is out and we got these new trustees in. So that doesn't change the provision of when it's supposed to end. The members of a business trust may dissolve it in accordance with the trust instrument, and may, upon proper grounds and where the circumstances warrant, bring an action in equity to procure its dissolution. A court of equity may, on a proper showing, decree the dissolution and liquidation of a business trust prior to the time specified in the trust instrument for its termination. A minority shareholder cannot arbitrarily and without equitable grounds demand the dissolution of the trust contrary to the terms of the trust instrument and before the objects of the trust have been accomplished. Nor may a shareholder in a business trust, even though in legal contemplation it is regarded as a partnership, assert a partner's arbitrary right of dissolution to obtain a dissolution of the trust during its lifetime in a manner different from that provided in the trust instrument. And the reason why is because in almost all cases, it was called a partnership under a specific instance, a specific activity or transaction. So it doesn't stop it from being a trust in all other regards, just that it was labeled a partnership for a specific instance. So it doesn't give them that power to terminate it. And it has been held that a person who did not join in the trust agreement is not entitled to a decree setting aside or declaring void the agreement, where to do so would result in injury to all of the parties. But where a business trust falls within the constitutional definition of a corporation, the right of the state to terminate its activities for failure to comply with statutes regulating corporations has been recognized. So think about what they're saying right here, right? But where a business trust falls within the constitutional definition of a corporation, the right of the state has to terminate its activities for failure to comply with the statutes regulating corporations has been recognized. And that's big right there. Let's read what that says. That's Illinois case too. No, it ain't my brand. Quo warranto lies against trustees who carry on business as a corporation without incorporating as required by law. As a general rule, and unless the trust instrument so provides, the death of one or more shareholders of a business trust does not have the effect of dissolving or terminating the organization, nor will the acquisition of all the shares of the Massachusetts by such other nor will the acquisition of all the shares of a Massachusetts trust by another such trust terminate or destroy the separate existence of the former trust. So here you go. That's why it's different than the one they first stated. Over here is changing the trustees, right? But down here it says all the shares were acquired by another trust. That doesn't terminate the existence of the former. The conveyance of the trust property by the trustees does not terminate their trusteeship with respect to duties remaining after such conveyance. And the sale of the property of business trust in foreclosure proceedings does not amount to a dissolution of the trust where a trustee purchases the property at the sale under such circumstances that it inured to the benefit of the original shareholders, especially where the business trust remains thereafter in charge of a receiver appointed by the court. Frequently, the trust instrument provides that upon the expiration of the term of the trust, the trustee shall wind up the affairs of the trust, liquidate its assets, and distribute the proceeds among the shareholders. And what you see here, you're not going to see property going to the shareholders, right? Because that would otherwise mean that the purpose of the trust could be for protecting and conserving property. So the trust purpose has to be business and for it to make income for the beneficiaries. And that's not only in its dealings, but the property also. So it's like you got to take that into consideration that on what the beneficiaries are ultimately going to get or receive at the end of the term. Where the trustees are given the power to terminate the trust at their discretion by dividing the trust fund among the shareholders, it has been held that they may not terminate it in another fashion. Upon the termination of the trust, the functions and powers of the trustees as such come to an end, except for the purpose of winding up the business and distributing the remaining assets among the shareholders. And here they got the resources, the legal forms. Is number 4. Neither trustees nor the court may compel objecting shareholders to accept shares in a new trust purporting to be created to operate for a period additional to that limited by the trust instrument, and to which the property of the former trust is conveyed by the original trustees, regardless of how advantageous it may be for the other shareholders. See, so it's like, okay, you can't make shareholders take on the new shares because you want to transfer them. You have to talk them into it to accept it. But if they so choose to opt out, then that's the end of their portion of that trust. Like, it's over with, for them at least. For their portion of the transfer, that's really what really matters too. They don't have right to the whole thing. They only have a right to their proportional share. The rights of shareholders with respect to dissolution of a business trust are determined by the provisions of the trust instrument and the terms of certificates of shares. A provision of the Declaration of Trust that the shareholders shall have no right to call for a partition or division of trust property or to institute any court proceedings, except at the expiration of the term of the trust, does not preclude them from maintaining an action on the ground that the trust has expired, or from securing a judicial determination of that question. meaning they're asking when is it supposed to expire, right? Because there's ambiguity. Dissolution of business trust sought by minority stockholder of a corporation whose other stockholders formed a formed trust to perfect title to corporation property by which minority stockholders profited. I read that one. The fact that the shares of a trust are transferable indicates an intention that such transfer or the death of the shareholder will not result in a dissolution of the trust. This I would want to read because they're making it specific. So I really need to put these on my phone. No, I can't delete that one. So it says the fact that the shares of the trust are transferable indicates an intention that such transfer or the death of the shareholder will not result in a dissolution of the trust. I would make it transferable, but I would regulate it. Like, as long as you don't violate some alienation rule or perpetuity or whatever, I would regulate it to heirship or something like that, or by will, where same thing with no corporation can ever be a shareholder or a beneficiary, things like that. Holding that a judgment against the trustees was not invalid because of their conveyance of the trust estate prior to the entry of the judgment. It's a good case right here, Schumann. In a Massachusetts trust, provision is commonly made for a ratable sharing in the proceeds upon termination. Grounds for and circumstance warranting equitable action and relief. Although the Court of General Equity Jurisdiction has the power to decree the termination of a business trust on the ground that it has expired by the terms of the trust, a court of equity will not decree the final dissolution of a business trust, contrary to the terms of the trust instrument, without a very clear showing of necessity. It has been held that a court has no power to dissolve such a trust in violation of the provisions of the trust instrument in the absence of a showing that the business of the trust cannot be continued. And that's too a provision that you want to put on there too. Like if you put a date that it will last for 20 years and that's it, right? Well, then what happens if the business is a complete failure? Well, then you could put a supplement to that the only time that it can terminate is if the funds are less than $50,000 or something in the account or whatever. There's no more property. It could be anything. It could be a variety of things to terminate it just a little bit earlier. And the right of minority shareholders to maintain such an action in absence of provision of the trust instrument giving them the right has been said to depend upon the showing that the purpose of the trust are no longer capable of fulfillment under proper management, or that the business could not be continued or contemplated by the trust instrument. The facts that the trustees of a business trust are not pursuing the purposes of the trust, and that they have paid no dividends to the shareholders, while perhaps proper to be considered in a proceeding to remove the trustees, are not a ground on which the shareholders may maintain an action to dissolve the trust, in the absence of a showing that the trust could not be continued under proper management. And the mere fact that a subscriber purchased shares under the belief that the officers and many of the other subscribers were in favor of closing out the affairs of the trust does not entitle him to a dissolution of the trust without other grounds and prior to the accomplishment of the purposes of the trust. On the other hand, it has been held that a court of equity has inherent power to appoint a receiver to liquidate a business trust where fraud, mismanagement, or abuse of trust is present, whether or not insolvency is likewise present. A hopeless deadlock in the management of a trust paralyzing its business and activities may warrant a court in dissolving the trust before the expiration of its term. And this is beneficiaries most of the time. Trustees probably can too, but beneficiaries most of the time. It's all about showing, right? It'll violate the trust indenture, but in the end, man, if it cannot exist no more, if it can't function, then who is it really hurting? You know, especially if there's cost and not to say debt, but cost, fees, and continuing payments that have to be made every so often. And the facts that the parties to a trust agreement organized the trust and became shareholders under the mistaken belief that a provision of the trust instrument expressly purporting to do so was effectual to exempt them for personal liability for the debts of the trust, and that by subsequent judicial decisions the law was established that such shareholders were personally liable notwithstanding such provisions, were held grounds for the dissolution of the trust at the suit of the shareholders. You have to read specifics on that court case. Liquidation of a temporarily solvent business has been held proper where the capital structure of the trust, although not subject to the controls of federal legislation governing investment companies, but failing to comply with the standards and safeguards prescribed therein, would permit controlling shareholders to launch the trust upon speculative enterprises making future insolvency likely and threatening the rights of debenture, the debt holders, right? And where the controlling shareholders and the Securities and Exchange Commission were unable to agree upon an acceptable plan for reorganization of the thing. I forgot what this, I know these can be notes. Yeah, an unsecured loan certificate issued by a company. A long-term security yielding a fixed rate of investment issued by a company and secure. See, when I read these definitions, I understand that I'm reading a general definition of these. I didn't go and read these definitions that apply to a specific statute or anything like that. This is just a general idea of what they are. Footnotes: minority shareholders were held to have or right to maintain a suit to dissolve and terminate the trust on the ground of the fraud and mismanagement on the part of the trustees, at least without a showing that the business could not be continued by the appointment of new trustees or otherwise. Holding that the failure of the Investment Company Act of 1940 to specifically mention the inherent power of equity to liquidate or reorganize a corporation or business trust where fraud, mismanagement, or abuse of a trust were present does not deprive the court of this aspect of its jurisdiction in actions brought under this act. And the reason why is that is a principle of law that they have, that the court has, to protect a class of persons in most cases. That's why, like, some things, just because it's not in the statute itself, right? Well, it's a principle of law that they have some power over, and they have the authority to do. Scope of equitable relief. Where a court of equity has once assumed jurisdiction of an action to dissolve a business trust, it may adjust all the rights between the parties and will retain jurisdiction until the end is accomplished. In a representative suit to terminate a trust, the court may require an accounting by the trustees, may enjoin the prosecution of other suits affecting the trust to avoid multiplicity of action, and may partition the property of the trust among the parties. Where equity has taken jurisdiction of an action to reorganize or liquidate a business trust on grounds of insolvency and has found the trustees guilty of gross abuse of trust, the supervening subrogation. What is this word? Unless I'm saying it wrong. Supervening? occurring as an interruption to an existing situation. Supervening insolvency of the trust and the removal of the offending trustees will not terminate the court's jurisdiction. The shareholders have no right to a partition of the trust property prior to the dissolution or termination of the business trust, and they give you a section if you scroll up to section 33. So part 10, receivership, reorganization, or merger. Section 95, receivership. The general equitable principles permitting the appointment of a receiver by a court of equity when conditions warrant such action apply to business trust. Whether a receiver for a business trust will or will not be appointed ordinarily rests on the sound discretion of the trial court. Such a court may, where the conservation of the trust property and the successful management of its business require it, appoint a receiver to operate the business of the trust. The facts that such a trust is insolvent and that, unless prevented, the trustees will dissipate the assets of the trust estate constitute a ground for the appointment of a receiver for the trust. Where a business trust is being mismanaged or is in danger of being lost to the shareholders through fraud, collusion, or mismanagement on the part of the trustees, a court of equity has inherent power to appoint a receiver to take charge of the property and assets of the trust to prevent loss to the shareholders. Where no substantial rights will be unduly infringed thereby, it is within the discretion of the trial court to appoint a temporary receiver pending an action by shareholders against the trustees of a business trust for an accounting, or as an incident to injunctive relief sought by shareholders against the trustees, where the receivership is necessary to render the injunction effective, but shareholders are not entitled to the appointment of a receiver for the trust as an ancillary process to aid them in the collection of an alleged individual debt of the trustees to them. Generally, the receiver of a business trust takes its assets subject to the equities which existed as against the trust. The rule applicable to public service corporations with respect to priorities of claims for current supplies was held to be applicable in a receivership involving a business trust which carried on a public service business. I like to read that right there. 14. Number 15. And they gave me nothing. Warburton versus Perkins, a Maryland case. The termination of a receivership also lies within the judicial discretion of the court, in the exercise of which the court will consider the rights and interests of all parties concerned. A court of equity in terminating receivership of a business trust has inherent power to order such measures as are necessary or proper to see that the property of the trust is turned over to one legally entitled thereto. Hence, the court may, in its discretion, order the shareholders to be notified of a motion to terminate the receivership and give them an opportunity to be heard thereon. I'll give you a section, American Law Review, Receivership for 3rd edition. Where co-trustees of a business trust held shares of a trust in equal numbers and were sole trustees, and one intended to use authority as co-trustee to inure trust, court had power to order dissolution and distribution of assets at request of the other co-trustee. Appointment of receiver to manage business trust properties was inappropriate relief where no other form of relief was additionally ordered. Holding further that the fact that a majority of shareholders oppose the proceedings does not necessarily preclude the court from appointing such a temporary receiver. In an action by shareholders against trustees for an accounting and to recover sums misappropriated and negligently lost by the trustees, it is proper, when necessary to the relief sought and to prevent further loss, to appoint a receiver of the trust estate. Hence, appointment of such receiver after the institution of a suit against the trust to cancel a mortgage was held not to defeat the right of cancellation. Holding that receivership is for the benefit of all shareholders, and consequently it will not be terminated merely because the particular shareholders at whose instance the receiver was appointed request that receivership be ended. So they went to go ask for a receiver, then they didn't want it no more, and then they told them no. Section 96, reorganization or merger generally. It may be a merger of several, there may be a merger of several business trusts, which may be affected by implication from the manner in which the business of the several trusts are conducted. So this right here, especially if all the persons are the same trustees, same beneficiaries and all that, and they're doing business together, there's interaction between them, no doubt the court's going to put all them together and say it's one trust. No doubt. Unless the indentures are vastly different. I don't want to say a little bit different because I doubt that would work, but it has to be a substantial difference. And the doctrine of estoppel has been invoked against a business trust seeking to stand upon a separate legal entity from that of an organization to whose business it succeeded. However, it has been held that the trustees of one business trust cannot, by any partnership arrangement with another trust, divest themselves of their personal duty to manage and control the trust estate confided in their care, which is a given. The trustees, where the trust agreement authorizes it, create a subsidiary or auxiliary trust, which is true. You could create and, you know what I'm saying? Bankruptcy reorganizations of business trusts are treated in an article on bankruptcy. Principle of implied merger applied where two business trusts were mere instrumentalities of the same persons and had complete identity of control and management. Their assets were intermingled, their accounts confused, their affairs completely scrambled, and both were operated practically as one organization. So here they at least gave you criteria. Same persons, same identity. So I'm guessing the instrument said the same thing, right? For the persons that were in control. You know, so it's a thing to think about. A business trust organized to take over a portion of a business of a pre-existing partnership and bearing the same name as the partnership with the addition of the word company has been held to be estopped to object to the application of a credit due to it upon an indebtedness owned by the partnership, where by its conduct it led the creditor reasonably to believe that it was dealing with the partnership or a firm succeeding to its business and liabilities. Section 97, incorporation, merger with or transfer to corporation. Where the terms of the trust instrument authorize it, a business trust may be reorganized by the creation of a corporation. The conveyance of the trust property to the corporation and the distribution of the corporate shares among the shareholders of the trust according to their respective interest. In the absence of a provision of the trust instrument expressly authorizing the transfer of the trust estate to a corporation, the power to do so may be found in general provisions empowering the trustees to convey the trust property or to terminate the trust and liquidate its assets. However, the trustees will be enjoined from carrying out a plan of reorganization of a business in the form of a corporation where the powers and objects of the corporation are substantially broader than the objects of the trust and the power of the trustees thereunto. right? What's that concept? If there's the thing that you cannot do, right? You don't have, and you also don't have the power to do for someone else to do it too, right? I might be saying it wrong, but it comes out to that. It has been said that no court has jurisdiction simply to rewrite a contract at the behest of dissident parties or to convert their trust indenture into a corporation in the absence of practically unanimous consent. It has been held that a corporation organized to take over a business and property of a business trust, and to which the property of the trust was conveyed, takes such property subject to the rights and claims of the creditors of the trust, and that a creditor of a business trust may maintain an action for discovery to determine what assets have been transferred by the trust to the corporation organized by those interested in the trust. The authority of the trustees to convey the assets of the trust to a corporation is sometimes so conferred in the trust instrument as to be limited to a conveyance subject to the terms of the trust, so that a grantee corporation holds the same as trustee. Trust instrument authorizing the trustees to engage in the business of owning, buying, selling, and otherwise acquiring or disposing of oil and gas royalties and acreage, developed and undeveloped, while the corporation to which it was proposed to convey the trust property in exchange for its shares was authorized to engage generally in oil and gas prospecting, producing, refining, processing, and distributing. That might be a good case to read. In a general sense, not to say specifically oil and gas, but it's the fact that the trust instrument, its business was for buying, selling, and owning, and otherwise acquiring and disposing these, right? Where on the other side, you had the corporation that had gas prospecting, so they were refining, producing, processing, and distributing. That would be a worthwhile case. I think I know this case right here. However, the rule relating to corporations, to the effect that the funds and property of a defunct corporation are a trust fund in the hands of the directors for the benefit of stockholders and creditors, and that when one corporation buys out the property of another corporation so that the first becomes defunct, the purchaser becomes responsible for the debts of the defunct concern, has been held not to apply in the case where a business trust sells its assets in a jurisdiction which treats such trusts as partnerships. That's Texas. So it says the rule relating to corporations, to the effect that funds and property of a defunct corporation are a trust fund in the hands of directors for the benefit of the stockholders and creditors, and when one corporation buys out the property of another corporation so that the first becomes defunct, the purchaser becomes responsible. So this is the principle, right? All this is the principle, right? Because normally they would be liable for those debts. But it has been held not to apply in the case where the business trust sells its assets in a jurisdiction which treats such trust as a partnership. And that's a Texas case. But even in such a jurisdiction, it has been held that a corporation organized by a trustee of a business trust pursuant to a plan conceived at the time of the formation of the trust and in accordance with the declaration of the trust for the purpose of taking over the assets of the trust and issuing stock of the corporation to the shareholders in the trust in proportion to their holdings, was liable to such a shareholder for the fraud perpetrated upon him by the trustee of the trust, at least to the extent of the property received from the trust, where the corporation took the assets of the trust with notice of all the facts and was operated by the same officers whose operated by the same officers who controlled the trust and gave no consideration for such assets except its agreement to issue its stock therefore. And that's it for this part right here. The next one, of course, will be practice and procedure, which will be the lawyer stuff, the action taking the court and so forth, defendants, plaintiffs, in a general sense and not specific. So hopefully you guys enjoyed this and learned a little bit more. And please like and subscribe to the Butterfly Monkey channel if you guys like what you hear. And of course, I hope to continue a reading on court cases that will be related to specific sections of business trust. So like specific court readings of practice and procedure, actions between the trust and third persons that will be added to that video that I made or will make or something like that. All right. But there's only one video left to make, and that's going to be this one. I'm going to make it in total. So that's going to be like an 1.5-hour video. So have fun. Hope you guys enjoyed, and please like and subscribe. Have a good one.